Mr. Favre, what are you doing? Help me. Please, Your Honor, I'm begging you for a second
All
chance.
right. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Victoria Lorraine Williams, case number 2024 CR 28. Ms. Williams, you were late.
Sorry, there was a couple of people in front of me with walkers that he was having to scan and all of that with the metal thingy.
You couldn't have arrived a few minutes early to make sure you got checked in.
Your Honor, in regards to the allegations, Ms. Williams will stipulate and waive her right to an evidentiary hearing.
I'll ask for recommendations from various persons, starting with Amber Norris on behalf of the state of Kansas.
Defendant has been on probation as of March 11th. Your Honor, it seems that been having problems from the beginning. The reporting, either rescheduling, being late, seems to be a bit of an issue. And then she was to have an evaluation in a certain period of time, and she basically lied to her court services officer not once but twice about just the scheduling of said evaluation. We're still basically where we were in March when the court first sentenced her regarding that particular condition. And it also appears that she's not going to be cooperative when it comes to UAs. She had multiple excuses why it was that she could not provide a UA at the time that he made the request. Not sure how successful she's going to be able to be on probation. I think probably her biggest issue is it doesn't seem like she can be honest with Mr. Smith or whoever is supervising her and follow their instruction.
Very well, Ms. Norris. Has there been any change in this defendant's performance on probation after you filed this warrant to show cause, which
I don't have anything at all. I haven't spoken to her since that date, showing that she's scheduled an evaluation, completed an evaluation, made a payment on her case. I don't know if she's clean or sober. So, Your Honor, based on our last conversation and no proof of anything, my position has not changed.
Very well, Mr. Smith. Mr. Favre, your recommendations to the court?
Judge, we are asking the court consider giving Ms. Williams a sanction here. Ms. Williams has obviously had a rough start to her probation. There's no doubt of that. It's been outlined very well by Mr. Smith. We asked the court to consider giving her a little bit more time to get this right. It is her first time up on probation violation here.
At this time, the court will address the defendant, Victoria Lorraine Williams, and I'll ask her personally. Does she have any statements that she wishes to make in mitigation of punishment here, or anything further that she would like to present to the court?
I did get a rough start, a lot going on, and there's no excuse in the world I can make for screwing up. I mean, I did it. I'll be the first to admit it. But it's like I asked Ryan, please allow me another opportunity to prove myself that I can do this. I don't have a choice. I have too much riding and too many people depending on me right now to be screwing up and doing this stupid shit. Pardon my French, Your Honor.
Who is depending on you?
Both my daughters. I reside with Curtis Westbrook. He's got congestive heart failure and he's got amyloidosis, which is a death sentence for him. Got a lot going on, and the life expectancy of somebody with amyloidosis is 4 months to 7 years. I can't turn my back on him, and I don't want to leave him high and dry.
Very well, Ms. Williams. Really, what the sentencing order was 6 months in the county jail.
I know.
You are given the opportunity for an alternative to actually serving that 6 months in the county jail by completing probation and its requirements. You were so inspired to be given that opportunity that you basically didn't do anything. The court wanted to take a rehabilitative approach in your case. In other words, make sure that if you had any substance abuse issues, that those got addressed early on in your probation period. Therefore, this court specifically ordered that you had to have your drug and alcohol evaluation completed within 60 days. You didn't take that seriously at all. You haven't started with any type of therapy or counseling or educational program because you don't even have your assessment done yet. And yet we're past 4 months from your sentencing date and you still haven't done it. But today you come in and say, well, I've at least scheduled it now. Well, it's a little bit too late, Ms. Williams. Either you choose to do the probation or you choose to do the jail time. It's not the court's decision here. Not really. It was yours. You had full control over whether you stayed in the community or not. You just said, I'm just going to blow this off and I'll get away with it. I think you were confident that you could just not do anything that you were specifically ordered by this court to do, and yet nothing was going to happen to you.
No, that's not true, Your
Wrong,
Honor.
wrong, wrong, wrong. So what did you do, Victoria? If you want me to give you another chance, just tell me what you did within the first 4 months of your probation that should give this court any reason to believe that you could successfully complete.
Nothing. I did report. I'm not gonna lie to you. I've been under so much stress and so much hanging over me, and I kind of gave up for a minute. It's like you said, maybe it is too little, too late. All I can say is, at least I'm trying now. At least I'm putting one foot forward to get it done and get it done correctly.
Why did it take a probation revocation proceeding to make that happen? So now,
I
4 months
did.
later, it's like, lo and behold, I get it now. I could go to jail for this.
And I
And then
thought
you
so
did not
too.
take any part of this case seriously. You didn't take any part of the probation seriously. It was just like, I'm in a rough time right now, so therefore I don't have to do this.
I can do this. I really can.
Saying it is one thing, doing it is another.
And that's exactly right. That couldn't be any more truer. But that's why I'm asking for a second chance. This is my first revocation, so I'm asking for another chance, please.
I don't know how many chances you think you get. There is no magic number of times you get to come back and get a minor sanction or a little slap on the wrist and get another chance. This court would have to have some reason to believe that you can be 100% successful on your probation program, and the court has no such confidence. Therefore, the court will enter an order at this time, having found substantial material violations of just about every important aspect of her probation. Court will enter an order outright revoking the probation of Victoria Lorraine Williams at this time, ordering her into custody to serve any remaining balance of the original 6-month sentence that was imposed in this case. At this time, orders Ms. Williams to the custody of the Butler County Sheriff's Office until she can be taken to the jail to serve the remaining balance of her sentence. Ms. Williams, you wanted to address the court one more time?
Yes, please. For Curtis's health and well-being, is there any way I could please request house arrest? I will do whatever. I swear to you, I can't leave him. I'm begging you. I will do whatever I have to do. I will do whatever. Please don't make me have to leave him.
Because I think under that situation, you should be allowed to make a call and let someone know what your situation is, which is essentially long-term incarceration.
Please,
okay.
Mr. Ricky, please consider house arrest, please.
I've considered it. I reject the notion that your request is rejected. Your request is rejected.
No, Mr. Favre, what are you doing? Help me. Mr. Ricky, please.
Normally I'm addressed as judge or your honor.
I'm sorry, Your Honor. I'm sorry. I don't know what to say. I'm just freaking out. Please consider house arrest. Please.
Judge,
I'm begging you.
Judge,
right.
I will.
Victoria, I just wish that
Please.
you would have taken this case as seriously before as you apparently do now.
Please, Your Honor, I'm begging you for a second chance.
All right. But when you have those kind of stakes involving other people in your life, I would think that you would take your probation even more seriously than someone who doesn't have those responsibilities.
Please.
Victoria only today takes her probation seriously.
No, Your Honor, I swear to you. Please. Please, Your
I understand
Honor.
Mr. Favre's request.
Please.
And your advocacy on your client's behalf, but the court is not going to change its previous order.
No, please, Ricky, please. Please don't make me do it. Please, you'll die.
Nothing you say is going to change my order at this time.
He's here. Can you talk to him?
I'm ordering him. I'm ordering Victoria into custody, and she has left the meeting, it would appear. The Williams matter will be in recess at this time, and the meeting may be ended for all. State of Kansas versus Victoria Lorraine Williams. It's case number 2024 CR 28. Victoria Williams appears from the Butler County Judicial Center Zoom location. Amber Norris on behalf of the state. This matter came before the court in July of 2024. At that time, the defendant stipulated to violations. The court ordered an outright revocation of her probation and ordered her to serve the remaining balance of her 6-month sentence in jail. Later, however, based on a request for the court to review that sentence and a request essentially for parole, this court did grant a reporting parole of 1 year on October 23 of 2024 with the requirements that she observe the law, report to her CSO as directed, not have any alcohol or illegal drugs, and pay off her case. Court did note that there were no other conditions. A warrant to show cause, which has been filed by Ryan Smith, the supervising parole officer in this case, that she failed to report as directed, failed to pay as directed, and failed to refrain from illegal drug use. Mr. Favre, what are your client's intentions here?
Regarding those allegations by Mr. Smith, I spoke to Mr. Smith earlier today, and I think he told me she was reporting. So I think that one is maybe not on the table anymore, but she would stipulate that she did test positive for methamphetamine on when tested by Mr. Smith, and also has not paid off her case yet.
What is the explanation for her failing to pay off her case?
Judge, I think it's a combination of things. She is spending significant amount of money to try to keep up her household. She babysits grandchildren. That takes up time. Her boyfriend, long-term boyfriend, Mr. Westbrook, has significant health issues. She has been having work sporadically, but she's working now, and she is working 2 jobs, taking care of him, as well as working construction jobs. So I think she's just had, a lot of time trying to get her house in order financially, as it were.
All right. But nevertheless, it is your position that her position will be that she has violated that term and condition of parole.
She has not yet. That is correct. She has not paid off her case yet, as is required by the court.
Mr. Smith, I suspect that at the time you filed this warrant to show cause, you were of the impression as a court services officer that Ms. Williams was not reporting as she had been directed to do. Is that a fair statement?
Your Honor, she did miss one appointment with me. That appointment was an appointment for her to come in and pay for a confirmation test. That is the one appointment that she did miss since her reinstatement.
So Mr. Favre is certainly of the opinion that she is reporting as directed since that time?
She has, Your Honor. Yes.
All right. Thank you for that confirmation. Generally speaking, I would believe you would have a due process right to a hearing where the state has the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence with your own evidence and with the assistance of your lawyer, confront any witnesses unless good cause was shown. And of course, I think you realize that the court could just once again order you to serve the remaining balance of this jail sentence in the jail. You understand that?
Yes, yes, Your Honor, I do.
So do you waive any formal hearing in the case and stipulate and agree that you committed the positive test for methamphetamine and the failure to pay off the case?
Yeah, I admit I haven't paid off my case. I just got working where I'm actually getting paid and not just doing it because I have to do it. I did test positive, but it's not for the reason why you all think. It's not that I was using. It's not that I am using. I learned about meth residue and dermal absorption the hard way. I've smoked meth in my home for 3 years. Everything in my home was contaminated. I had no idea of this. I had to buy a substance that would actually help break down the meth residue before I could actually even get my home clean. I informed Ryan of every step that I took through this whole process. I let him know exactly what was going on with everything. I did finally get my home clean, got everything repainted and washed, and everything broke down. But yeah, I did. And I informed him that I was going to test positive for the next test that I took because I had been doing all the cleaning, and I told him my levels were going to be high due to the amount of cleaning I'd been doing. And it was really nasty, and it was really mortifying learning about it. It was, the ramifications of an addiction are still haunting me.
Mr. Smith, do we have a lab confirmation of the positive test for meth? And your assessment of the levels? Your voice is very faded at this point, Mr. Smith. I just want to make sure everyone can hear you.
So the first test, I believe, Your Honor, was 298 nanograms per milliliter. And then a subsequent test, about 3 weeks later, 3.5 weeks later, it had jumped from that 298 nanograms to over 2,500 nanograms per mil.
All right. The Court will find at this point that Ms. Williams has waived a hearing knowingly and stipulate and agrees that she's committed both of the violations that remain in this case, the positive test connoting use of that illegal substance and not paying off her case. These are substantial and material violations of the terms and conditions of her parole. Recommendation by the state regarding disposition here.
Your Honor, this is defendant's second warrant to show cause in this case. As the court recalls, we were here in July and the court actually did revoke the defendant and place her in the county jail. She was in there for approximately 32 days, and then the court did place her on parole. And here we find ourselves back before the court for additional violations in the case. At this point, Your Honor, the defendant has 33 days of jail time credit, and we would be suggesting to the court that the defendant's probation be revoked outright and that she serve 4 months in the county jail with credit for time served, which would be basically 2 months off of the 6 months that she had originally been sentenced. And then the court closed the case and the money to go, money's still doing it and go to collections. She's obviously not doing very well on probation/parole.
I understand your position, Ms. Norris. Mr. Smith, would you have an independent recommendation to make to the court today?
No, Your Honor, I would not.
Thank you.
I agree that her attitude has improved since being placed on back on the parole, but obviously the tests show that she still has methamphetamine in her system.
Mr. Favre, your recommendations regarding an appropriate disposition here.
Judge, this is her first time on parole revocation. Ms. Norris correctly states that she was previously revoked once for probation, as the court also noted. She has had a really hard road, but I think she has shown some promise. She had another case that was pending that she has taken responsibility for, has entered a felony plea, and that is going to be set for sentencing. It is set for sentencing in the next, I think, month and a half. Miss Williams is working, as she noted. She's also taking care of a boyfriend that has very significant health issues and is currently receiving medications through a PIC line. She's got a lot of things going on in her life that would be disruptive not only to her but to other people. She is essentially being violated for her substance abuse struggles. And I'm not qualified enough to make a claim on this dermal absorption claim of hers. I know that it's possible to have skin contact absorption. I know that much. I don't know if it's enough to justify the levels jumping, and I understand the presumption of Mr. Smith and the state. That level jump is not going to be because of dermal absorption, but because she relapsed. But I feel like she's been pretty honest about her usage lately, and she has been reporting regularly to Mr. Smith. So we're asking the court to consider giving her an intermediate sanction and releasing her on probation. I'm not sorry, back on parole to finish up with an order to do treatment, perhaps. Previously, the court not ordered to do treatment. We'd ask the court to consider that. She obviously needs it. In the alternative, we'd ask the court to consider house arrest for whatever sanction it deems appropriate. Miss Williams is willing to pay for that house arrest, and that would allow her to continue to take care of her ailing long-term boyfriend as well as her other duties around the house.
Ms. Williams, at this time, the court will address you personally, and I'll ask you, do you have any additional statements in mitigation of punishment or anything further that you would like to present?
First, Mr. Westbrook is not my boyfriend. He's my best friend, but I just want to make that clear. He is not my boyfriend. He does have a lot of medical problems right now. He currently has a chest tube in him. He is just recovering from being in the hospital for the last 2 months with septic arthritis. I do have to administer PIC line antibiotics 3 times a day to him. I do everything for him. He can't hardly walk or nothing no more. I would ask the courts to please consider house arrest in this case. I have no problem going and taking a drug and alcohol evaluation and following recommendations with it. I have been staying clean. I regret that it was in my home. I'm working now finally. I did get a job with vaping. I do a lot of their foreclosures and cleanouts and removals for them. So I am finally making money. I will be able to pay my fines off. So I just ask that if you would please put me on the house arrest. That way I can continue to meet my obligations on the outside. I mean, I leave it at your discretion.
What
Thank
about
you.
your obligations here?
Your Honor, I mean, I'm trying. I am working 2 jobs now. I am getting paid for working for Mr. Westbrook now. And I also am working so I will be able to pay the fines off now. I didn't have financial stability before. I do now. I've been working 2 jobs for about a month and a half now. I babysit my 4 grandkids for my daughters when they're working. So I do have income coming in now, which has been a big relief off of me. I just had to catch up a lot of personal bills and bills at the home, the electric mortgage and all that. I probably should have made a payment on my fines. I admit that, but I am working now, so I can get them paid off very quickly, next 30 days.
Ms. Williams, I do recall the hearing back in July of 2024 when this court ordered an outright revocation of your probation and ordered you to serve the remaining balance of 6 months, which was virtually all of it at the time. I know how distraught you were at the time. This court, when you were called back into court on a request that you had made, essentially the court then acting on that request granted you parole, which quite frankly, this court doesn't do in every case. And again, very frankly, rarely. Granted
I'm
you one of
thankful.
those special exceptions, kind of like how the presidents are handing out pardons right and left here in the last month or so. It's a special release from a sentence that's been ordered and a probation that's been revoked. And I
Yes, sir.
thought that I impressed upon you at the time just how important it was that since you were given truly a second chance. I mean, you were ordered to serve it all. Then you were released from that sentence early on conditions. I pared down those conditions very specifically to just 4 conditions that you had to meet instead of that whole laundry list, which probationers generally have put in front of them to try to set you up for success. And I would have thought that you would have been so thankful about getting that second opportunity that you would have made every possible effort to comply with those parole conditions. I have had some success with
I was.
parolees on misdemeanors really seeing the light, realizing how close they were to serving an entire long jail sentence. And then they take advantage of that second opportunity and they are model persons who report to court services at that point. Well, that isn't you.
I have.
The payment thing I know is difficult for someone who struggles financially. But what I would have expected from you is a regular and consistent effort every month. If you couldn't pay 50, you pay 5 or 10, but you pay something to let the court and the court services department know that you're making an effort, that you're carving out something toward your case. But that's not the most important thing here. I'm extremely disappointed that you would ever have a positive methamphetamine result. And quite frankly, Victoria, I don't buy this whole skin absorption thing. You used methamphetamine. It's a dangerous street drug that you have no business being around. And here you are with responsibilities toward children and apparently a man who relies upon you for some sort of medical and care assistance while you're using meth or you're around meth. And that those two are inconsistent in the court's view. You have not been successful on parole. But with that said, this court had entered an order earlier today in a case that has some similarity to this one. And even the state, and I think it's a very magnanimous thing that Ms. Norris recommended here to actually recommend a modified shortened sentence, which she certainly doesn't have to do. But she did here, and the court's going to grant that relief. But it's going to be in the same way that I did that for the earlier defendant in the case. Ms. Norris, it's my understanding she has 33 days of prior jail time credit. Is
That's
that
correct, Your Honor.
I'm going to reduce the sentence in this case to 93 days and order Ms. Williams into immediate custody of the Butler County Sheriff's Office to serve the remaining balance of that 93-day sentence. She apparently has 33 days. 60 more days will be served by this defendant without release privileges as a sanction for noncompliance on the structured parole that this court had earlier ordered in this case. At that point, her sentence is flattened. If it hasn't been sent to collections, the court will declare any unpaid amounts to be immediately due, payable, and collectible. Ms. Williams, you're going to need to take care of those. They're not going to go away. And
Yes, Your
with the
Honor.
collection agency, you're going to owe even more. But that's the complication you caused yourself. Ms. Norris, do you need any further clarification regarding the court's order made here today?
I don't believe so, Your Honor. Thank you.
Mr. Favre, anything further?
No, Your Honor. Thank you.
All right, then I'm ordering Ms. Williams into immediate custody of the sheriff's representatives until she can be transferred to the jail to serve 60 more consecutive days in incarceration. And then her case will be flattened and closed. If there's nothing further, then the Victoria Lorraine Williams matter will be in recess.
This transcript presents a detailed courtroom proceeding involving the case of Victoria Lorraine Williams, heard in the District Court of Butler County, Kansas. The case revolves around repeated violations of probation and later parole conditions, ultimately leading to the revocation of her release and imposition of jail time. The hearing offers a deep insight into how courts evaluate compliance, credibility, responsibility, and the balance between rehabilitation and punishment. At the outset, the defendant appears before the court already under scrutiny for her behavior. The judge notes that she was late and her explanation delays caused by security screening fails to impress the court. This moment, though seemingly minor, sets the tone for the proceeding. As punctuality and responsibility are key expectations for individuals under court supervision, the judge's response indicates an early concern about the defendant's reliability and seriousness. Toward her legal obligations, the prosecution then outlines a pattern of ongoing noncompliance during probation. According to the state, the defendant had struggled from the very beginning. She repeatedly failed to report properly, was frequently late or rescheduled appointments, and most importantly, failed to complete a court-ordered drug and alcohol evaluation within the required time frame. Even more concerning was the allegation that she had lied to her supervising officer about scheduling the evaluation, not once but twice. This behavior undermined the trust necessary for probation to function effectively. Additionally, the prosecution raised concerns about her unwillingness or inability to comply with drug testing requirements. She had provided multiple excuses to avoid submitting a urine analysis, UA, raising doubts about her sobriety and willingness to cooperate. The state concluded that there was no evidence of improvement since the initial violations and maintained that the defendant was not demonstrating the commitment required to succeed on probation. In response, the defense acknowledged the defendant's poor start but requested leniency, emphasizing that this was her first probation violation hearing. The defense argued that she deserved another opportunity to correct her behavior and asked the court to consider a lesser sanction rather than full revocation when given the opportunity to speak. Victoria Williams admitted her failures openly. She acknowledged that she had screwed up and offered no excuses. Though she explained that she had been under significant personal stress, she described her responsibilities, including caring for her daughters and assisting a seriously ill individual suffering from congestive heart failure and other life-threatening conditions. Her plea focused heavily on the idea that others depended on her and that she needed another chance to prove herself. Despite her emotional appeal, the judge delivered a firm and critical response. He emphasized that the original sentence had already been lenient, offering her probation instead of serving 6 months in jail. The purpose of probation, he explained, was rehabilitation, particularly addressing any substance abuse issues early in the process. However, the defendant had failed to take even the most basic steps, such as completing her evaluation. Even after 4 months, the judge framed the situation as a matter of personal choice. She had been given the opportunity to remain in the community, but chose not to comply with the conditions. He rejected her explanation that stress justified her inaction, stating that many individuals face difficult circumstances yet still meet their legal obligations. The court also pointed out that her sudden willingness to comply only arose after facing revocation. suggesting that her motivation was driven by fear of consequences rather than genuine commitment. Ultimately, the court found substantial and material violations of probation and ordered a full revocation. The defendant was sentenced to serve the remaining balance of her original 6-month jail term. When she pleaded for house arrest instead of jail, citing her caregiving responsibilities, the judge denied the request. He expressed frustration that she only began to take her situation seriously at the last moment, rather than earlier when it could have made a difference. However, the case did not end there. A later proceeding revealed that the court had reconsidered her situation and granted her a second opportunity in the form of parole, which is even more discretionary than probation. This decision reflected the court's willingness to offer rehabilitation opportunities despite prior failures. The conditions of parole were simplified to increase her chances of success. Obey the law. Report to her supervising officer, avoid drugs and alcohol, and pay off her financial obligations. Unfortunately, the defendant once again violated these conditions. She failed to make required payments and tested positive for methamphetamine. Although she admitted to the violations, she attempted to explain the positive drug test by claiming it resulted from dermal absorption of meth residue while cleaning her home, which had previously been contaminated due to past drug use. She argued that the residue caused the positive test, not active drug use. The court examined this claim carefully, including lab results showing a significant increase in drug levels, from 298 nanograms to over 2,500 nanograms. This sharp increase strongly suggested active use rather than passive exposure. The judge explicitly rejected her explanation, stating that he did not believe the dermal absorption argument and concluded that she had indeed used methamphetamine. The prosecution recommended a reduced but still significant jail sentence, acknowledging that the defendant had already served some time. The defense again requested leniency, suggesting treatment or house arrest, and highlighted her responsibilities, including employment and caregiving duties. When addressing the court again, the defendant reiterated her situation. She described her efforts to work 2 jobs, care for an ill individual, and support her family. She insisted that she was trying to improve and requested house arrest so she could continue fulfilling her responsibilities. Despite these arguments, the judge remained firm. He acknowledged that the court had already given her an extraordinary second chance through parole, something not commonly granted. He emphasized that he had deliberately reduced the number of conditions to make compliance easier, yet she still failed to meet even those minimal requirements. The judge expressed particular disappointment in her continued drug use, noting that it was incompatible with her responsibilities toward children and vulnerable individuals. He stated that her actions demonstrated a lack of seriousness and responsibility, and that her repeated violations left the court with little confidence in her ability to comply in the future. In the final decision, the court imposed a modified sentence of 93 days, taking into account time already served. With 33 days of credit, she was ordered to serve an additional 60 days in jail without release privileges. The judge also ordered that any remaining financial obligations be enforced, potentially through collections if unpaid. In conclusion, this case illustrates the progressive escalation of consequences when a defendant repeatedly fails to comply with court-ordered conditions. The court initially pursued a rehabilitative approach, offering probation and later parole, but shifted toward punishment after repeated violations. The judge's reasoning highlights several key factors: the importance of honesty, consistent effort, respect for court orders, and the ability to demonstrate genuine change. Victoria Williams' case underscores a critical lesson. Courts may offer multiple opportunities for rehabilitation, but those opportunities are conditional and finite. When a defendant repeatedly fails to meet even basic requirements, the court ultimately prioritizes accountability and enforcement over continued leniency. Her situation demonstrates how personal struggles, while relevant, cannot excuse ongoing noncompliance, especially when public safety and legal integrity are at stake.